Good morning. This is Attorney Vincent Davis, and these are my office hours. I am joined by my co host, Miss G. Good morning, Miss G.
Good morning.
So, this morning, office hours, Saturday, the weekend, what are we talking about?
Um,
I
okay,
saw a
so
note.
it's
Grace said we were talking about
so in
TPR.
cases approaching TPR, which is termination of parental rights, last chance opportunities. So there are parents where their cases is approaching to terminate their rights, and so basically, what are the last chance opportunities for them? Because a lot of parents don't really they're so focused on completing courses, classes, that they lose their jobs, they lose their mind, they lose their identity, their kids. So they're not really aware of what is happening in their case. So I want everyone to be aware of the termination of you know, when you're going towards terminating your parental rights, and then what is the remedy, the last minute remedy.
The last minute remedy that you have, it's generally twofold. Um, Number one, you probably want to file a motion for a bonding study. That should have been done earlier in the case, say, for example, when you lost your family reunification services. But if you haven't done it, do it, do it now. The bonding study is a study by usually a psychologist, court appointed psychologist, that can help you with several defenses. Number one, when the psychologist interviews the child, the psychologist may come up with a theory that the child is not adoptable for many different reasons. For example, a child may have severe emotional or behavioral problems.
Yeah,
Child has a serious medical condition.
yeah.
The evaluator may learn that the child is not with an adoptive family. The evaluator may know some of the background of the child, where the child has had multiple failed placements in foster care. The child may be, in California, that 12-year-old or older child who doesn't want to be adopted. And in California, if the child doesn't want to be adopted, there can be no termination of parental rights because that would leave the child without any parent. There's things like educational instability, a lot of things that the evaluator can learn about the child to say and come into court, hey, judge, this child is not adoptable. So if you terminate the parental rights, the child will be parentless. And the law doesn't want to have a child who's parentless. Number two is probably the most frequently used defense to termination, and that's called the parent-child beneficial relationship exception. It's actually mentioned in the case, in the statute. If the parent proves at the 2-6 hearing that terminating the child's parental rights would not be beneficial to the child, not to the parent, but to the child, then that can stop the termination and give the parent a lot more time to try to get back, on the saddle. There's something that a lot of people don't realize about proving that beneficial parent child relationship. And number one is your regular and consistent visitation with the child. One of the things that you notice at when you lose your family reunification services is that the social worker recommends that your visitation be cut down and reduced substantially. As I mentioned yesterday, when the social worker requests that, it's to help destroy your relationship with your child, your bond with your child. So that's why they ask. So all of a sudden, you go from 3 times a week, 2 hours a visit, to 1 time a month. And if you can imagine, in the long run, what
Mm-hmm.
happens if you go from 3 visits per week to 1 time a month for 120 days? No matter who you are, because we're all human beings,
Yeah.
whatever bond we had is going to be diminished. And there really is no reason for your visitation to be reduced other than to prevent you from proving the parent child beneficial relationship exception at the 2-6 hearing. So the person who's doing the evaluation can see the emotional, the psychological, and the physical bond that exists between a parent and child. And
Mm-hmm.
that person can do what's called a bonding study and do a written report for the court and present it at court. I'd have to say that every time there's a bonding study that is in your favor, you have a strong sense of winning the case, winning the 2-6 case, and preventing the termination of your rights. Have I ever seen a bonding study who said, don't terminate the rights, and the judge still terminates the rights? Yes, I have, but in my experience, it's very rare. So always get that bonding study. I'm in a case now where there's a big fight about the parents even getting a bonding study. The motion was made. The judge refused to allow them to have a bonding study, which is within the judge's discretion. However, we're arguing that the judge abused her discretion by not ordering the bonding study. And I say a writ was filed, and the writ has been pending for several months.
Mm-hmm.
And the court, as a matter of fact, the Court of Appeals has stopped the trial court judge from even having the 2-6 hearing on at least, I think, 2 occasions. So the bonding study issue is a really big issue. The next thing that you can talk about or think about with your lawyer is relative placement. Let's assume the child's in a strange foster home and not with a relative, a friendly relative who doesn't want to take the kid away from you. And, it's never too late for your relatives to step forward and try to get the child placed with them. All right. It's easier to make that happen early in the case. So, like everything in these cases, you got to see the big picture. You got to see that, relative placement is a good thing for you, not a bad thing.
Right.
I had many clients tell me I don't have relatives because they don't want the family to find out that they have a CPS case. They don't want the family to find out, oh, there was a drug issue or an alcohol issue or a domestic violence issue or a physical abuse issue or a sexual abuse issue. So they tell people, oh, we don't have relatives. The social workers are actually supposed to search for relatives, and a lot of them rely on the parent for that information. And I've seen a lot of judges say, well, your client didn't give the social worker any relatives to investigate. And that's not what the law says. Law says social worker must investigate. This is many years ago, the city and county of San Francisco lost a huge lawsuit because they didn't search for relatives. And I was just involved in a case not too long ago in San Francisco, And they don't do the search that they did for years. They actually hired an outside company to go and search for relatives. But the trick that they would use was, and I can only suspect that the county told them to do this, is that when they called up the relative, they would say, "Hey, Georgette, I'm calling for San Francisco County, and we got these kids that you're related to in foster care. Um, we just want to make sure that you don't want to take the kids because it's going to be expensive. Their Medicare, their support, their child care if you're working. They kind of lead them to make the relative say, "Oh, I don't want the kid." They say all the bad things, and they don't say all the good things, like the county will reimburse you for everything or provide for everything. So it's how relatives are approached about whether they say yes or no to take the child. So that's another thing that you can approach and you can investigate while you're approaching this, you know, 2-6 hearing. Now, one of the things that can be done is, you can strengthen your relationship with a child, especially a child that's 12 years of age or older. Because if they're 12 and they say, "Hey, I don't want to be adopted," the law is they can't be adopted. So, what goes into children who are, or any age children, is the social worker tries to promote the kid wanting to be adopted by the social worker. And that's something that you always got to watch out for. One of the things that I try to do where there's a significant sibling relationship is I try to prepare and argue for the sibling relationship. Remember, if your parental rights are terminated, the child has no relationship to anybody in the family, including siblings. So, you know, if the siblings are dependents of the court, you may not be able to talk to them, but sometimes the siblings are not dependents of the court, especially adult siblings. So you can use them to try to stop the termination as well as having the child placed there. I recently was involved in a case where the sibling was like in their mid 20s and would be a fine caretaker, except for the fact that the social worker said she was too young and not mature enough. And the interesting thing was she had never met the sibling and never talked to the sibling. So now the sibling is trying to get the child placed with them because the social worker never contacted the sibling, who lived in another state, by the way, and told them, "Hey, your brother or sister is in foster care."
Mm.
So, there are also standard due process procedural attacks that you can do at the 2-6 hearing or right before the 2-6 hearing. You can argue that if there's inadequate notice, failure to provide interpreters, denial of contested hearings in the past, improper limitation of testimony, um, failure to transport children to visits, failure to accommodate a disability is one defense that is growing. Um, there are federal laws with respect to Americans with disabilities, and it seems that a lot of counties aren't acknowledging that and are not providing accommodations with respect to visitation, with respect to classes. You know, what if they tell you go take a parenting class and you have a learning disability? Hmm. Your rights may be being violated by the county.
Wait a minute. That part right there. You said if the parent has a learning disability and the social worker insists on the parent going to a parenting class.
You ain't gonna learn anything if you have a learning disability unless some type of accommodation is made. Typically, in the setting of students with disability, that is special tutoring. special mentoring, right? When's the last time you heard a parent say, "Oh, I have a learning disability, a real learning disability, and I couldn't understand or learn anything from the parenting class."
I heard that a lot.
Yeah. Then the social worker is going to say, "We didn't learn anything from the parenting class." And if you don't bring up the fact that you have a disability and bring it up earlier in the case, right? You can say, "Well, you're violating federal law.
Wait
You're
a
not
minute.
you're not providing an accommodation."
Okay, that's understandable. However, a lot of the court appointed attorneys are telling their clients that if they bring that up to the judge from the beginning, they will not get their children back. The judge is going to see that they have no ability to care for the child or the children. I'm not joking you. This is happening a lot. And
Well,
it, and the mothers and fathers with ADHD and that doesn't
well,
mean they can't parent their children.
if you have a disability,
Right.
whatever kind of disability,
Hmm.
you need to be talking about it with your lawyer early on in the case. And if the lawyer's not willing to talk to you about it or gives you advice like you just said,
Hmm.
don't bring it up in front of the judge, you may want to seek a second opinion. As a matter of fact, I strongly recommend you seek a second opinion, and maybe you want to call us so that I can, you know, do a consult with you or something. Call Miss G or call me at the office at the number that's in the right-hand corner of this screen, which Miss G currently has blocked. But there's a phone number there, and it's 888-888-6582. You can call that number 24/7.
Um, Attorney Davis, I have a question. Can the parents sue, not sue, report that attorney to the state bar? Can the court appointed attorneys be reported to the state bar?
Yes.
Okay. So they're not untouchable. They're not protected by the state.
No, but
That's what I'm
you
confused about.
here's what you are confusing.
Hmm.
If an attorney does a wrongful act, the state bar will get involved. If the attorney makes a judgment call and decides not to tell you something about strategy, like don't bring that up, that's not, in my opinion, a state bar issue.
But he's using the disability.
But nothing. I said that's not a state bar issue. That's that attorney's
What?
opinion and strategy. Okay?
He,
Now, it may be a wrong opinion and a wrong strategy, but that's not what the state bar polices, right? If you think that an attorney did a wrong opinion or a wrong strategy, you have to go to court and sue the attorney for legal malpractice.
but don't you think that's deliberately done though? Wouldn't an attorney know
I don't think, as I've told you many times,
malice?
you don't know what's in the head of an attorney.
Nothing.
They could legitimately say, "Yeah, I thought that was an issue, and I that was my strategy."
How
Who are
can
you? Who are you to say that my strategy is wrong?
Okay, now I'm not talking. This is not a strategy. When a parent
It
has
is.
disability,
It
that's
is a
not a
strategy.
strategy not to tell the judge from the beginning.
It
Because
absolutely is a strategy. It's a bad strategy. It's probably a strategy that's incorrect, but it's a strategy.
Mm,
Just because you would do something different doesn't make the attorney not have a strategy.
right.
Here's a strategy. Let me tell you what one strategy is. And I
Hmm.
see it frequently. Hey, mom, go into court, say you're guilty, and we'll get the kids back in 6 months.
Well, that's obviously
That's
bad.
well, yeah, but it's a strategy.
It's a strategy to go against the parent. It's not a
No,
strategy to win the case for the parent.
it's a strategy that somebody can legitimately say that's what I thought should be done in the case.
No, 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 no. How can anyone in the right mind, let alone an attorney, um, say something like that? Plead guilty. You're going to get your kids back. Every moron, okay, on earth who is an attorney, except you, Mr. Davis, Um, know
Oh,
exactly,
Miss
know
G,
exactly what
Miss G,
pleading
how
guilty
many?
will bring you. Do you get
Miss,
me?
yeah, and I get, you know, I want to
And
be
I get Terry
respectful.
either. Yeah.
I want to be respectful, but you've never done a dependency case.
No, what I'm no, listen, you're not listening to me.
Oh,
Every
I understand it.
attorney, whether they just pass the bar or not, no, even if they're in college, every attorney knows they cannot just you can't plead guilty and get your children back. Come on, Davis.
That's not.
Even
It's not
a
true.
teenager knows that.
It's not true. There's a lot of reasons that I can think of where an attorney
Unbelievable.
may say that. It's a bad strategy, but it is a strategy.
Mm,
So, getting back to what we were talking about.
that's not a strategy. But anyways, we're gonna have to disagree on that one.
Okay. So, remember, I'm the guy with almost
I
40
don't
years of
care if you have
experience.
80 years. Common sense. I'm using common sense in the
How, no,
normal head of
you can't
humans.
use common sense in legal matters.
I
It
understand
doesn't
that.
work. How many
Okay.
cases you done?
Okay, can I say something?
How
You
many
can't
cases have
use
you
no,
done?
no, no. Don't go back and forth with me on that. There is a simple explanation. If somebody tells you to plead guilty to something to get you a better outcome, it doesn't make sense.
Okay.
Okay, it doesn't make sense. You cannot. That's that. They cannot be part of a normal strategy. That has to be a demonic strategy. Let me
That's
be
in your
clear.
opinion.
It
That's
doesn't
in your
matter.
opinion.
It doesn't matter if I did 5 cases. It doesn't matter if I did 58,000 cases. The point
Miss G is unfortunately not a lawyer, and she is giving you an opinion about herself, about what she thinks.
okay, if you mute me again, I'm going to log out of the show. Okay,
Okay.
but don't do that because the point I'm trying to make, you don't have to go through all this bullshit that you're doing right now, Vincent. All I'm saying is that anyone that tells you that you need to plead guilty to get
You
a
you
better
need a second.
outcome,
You
it
need a
doesn't
second
add
opinion.
up.
You need a second opinion. If somebody tells you you need to plead guilty, you need a second opinion. But as you know, Miss G, many people are taking that advice and not seeking the second opinion.
Mm. I hope you heard. I hope you read that. That was very rude and crazy what you did, because it's really rude when you do that to someone talking. And
Hey,
as an attorney, you should know that.
hey, Sammy, I hit the button by mistake. I
No, you
apologize.
didn't. No, 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 you didn't. You do this all the time. No, you didn't. Don't lie. Don't lie your way out of this. Okay? Yes, you're an attorney, and you would lie your way out of. No,
Sammy, I apologize. And you're right. Bob would not like that. He
no, he
would not
wouldn't.
at all.
Okay, let's move on.
By the
Anyway,
way, I want to mention something to you. I mentioned this to you before. I'm about to launch a CPS course. It's a 12-hour video course with slides and workbook and all that. And I'm about to launch a CPS app. A CPS app. I'm going to dedicate one or both of those things to Bob Pace. Anyway, what is Betty Joe saying this morning? Good morning, Betty Joe. You have to be one of the most loyal viewers that we have. Let's see, what happened when a family member calls the social worker at the day that the child is being removed and they never place the child with the family because they are out of state and there was an ICPC? Couldn't see the rest of the question. Can you put the question back up, Miss G? Uh, Out of state and there was an ICPC that was accepted. What happens? I'm going to tell you what happens. It's a great question for a lot of different reasons and a lot of different levels. Unless you do something, legally speaking, in front of the judge, nothing happens. Social worker gets her way. So the first thing you have to decide is you have to decide to go in front of the judge with the proper motion and petition in order to get the child placed with the relative in the foreign state. You know what that usually takes? It usually takes getting an attorney. So do not waste your time with the social worker trying to convince the social worker to place the child. If the social worker wants a child someplace, any place, the social worker will make it happen. That's one of the things that they can do within their discretion. So you talking to the social worker is a waste of time, Betty Jo. Get a lawyer, make a motion to enforce the ICPC, make a motion for de facto status, file a 388 petition for the judge to order placement with that relative. You can do all of those things and more. So remember what I said initially, Betty. Nothing happens unless you make it happen. And number two, don't waste your time with the social worker. Go directly to the judge for your remedies. All right. You want to get back to the 2-6?
Sure.
Where did we leave off? Oh, I
No,
was
you're
going to tell you this. File your 388 petition before the 2-6 hearing. Your 388 petition will get you more family reunification services, may get you the child placed with you, may get you more visitation, right? Visitation with the child, frequency, duration, nature, monitored to unmonitored. All of these things can help you. Have I ever seen this work? Yes, many times. Many times people file 388s before the 2-6 or during that waiting period. Have I ever seen that fail? Yes, I have. Many, many times I've seen it fail. But if it fails and you have a legitimate 388, there's something that you can do. You can file an appeal. You can file a writ. Just like the case I mentioned earlier, you can file a writ, and the Court of Appeals may stay the 2-6 hearing, as it has done in the case that I'm involved with right now. Okay? Now, when you file this 388, you're going to have to file the evidence that you have. You know, evidence of your sobriety, evidence of your housing stability, evidence of your, mental health treatment, um, evidence of your return from incarceration. A lot of times people have, especially fathers, have cases that they're losing because they're incarcerated for no other reason. It shouldn't be that way for a lot of different reasons, and different legal reasons, and we can talk about that on another show. But show that you've reestablished the bond. Show that their relative placement is now available. The biggest mistake that a parent will make is waiting too long to file the 388 and filing a weak 388. The form itself is only like 4 pages, but if you just file that 4 pages, your 388 is likely to be denied. You got to add something. You got to add evidence, certificates, that type of thing to the 388. Okay? Now, when you get to the 2-6 hearing, one of the things you and your attorney have to do is cross-examine the social worker aggressively. Okay? You want to make sure that you put the social worker on the stand. I tell people all the time, you don't have a trial unless you have witnesses. Just arguing the report that the social worker wrote 99 times out of 100 is going to lead you to a loss. Why? Because the social worker's report is the only evidence the judge is going to consider. So when you get the social worker on the stand, you and your attorney should consider these areas. Um, quote, is the child adoptable and why, based upon what specific facts? Focus on the visits that you've had. Focus on the child didn't appear distressed. Focus on, is the caretaker committed to adoption? Were there any missing records in the delivered service logs that the social worker wrote? Are there uninvestigated relatives? Are there contradictions between reports? Are there contradictions between the delivered service logs and the report that the social worker filed? And sometimes there's a lot of discrepancies because the 2-6 report is not written by the social worker that's been on the case. Okay? So you want to make sure that you have a clean appellate record. So here's some combinations of things that I use as a checklist to try to win a 2-6 hearing. Okay, so I have basically 4 combinations of a defense. And this is all a template, all a checklist that I've developed. It can be easily changed. Okay, the first combination that I try to focus on is the parent's strong visitation, their strong bond, the bonding study, a weak adoptive placement, and that the child wants, no matter what age, wants ongoing contact. So that's combination A. Combination B is we have a strong relative placement argument. There's a weak investigation by the social worker, and legal guardianship is available. If the child is placed out of your custody permanently with legal guardianship, you still maintain your rights, and in the future, you can file a 388 to terminate the legal guardianship and get the child back. I think we have a couple cases in the office where we're doing that exact thing right now. Combination C is the powerful 388 shortly before the 2-6. And by shortly, I like to do it maybe 2 months, 3 months before the 2-6 hearing. And with that combination, the parent shows a dramatic and documented change. The last time I stopped at 2-6, it was because of this exact fact. The parent had made a complete turnaround in her services, in her drug testing, and the letters and certificates that she had maintained or obtained, were compelling, so that the judge would have to take the child or give the child back to the parent. The last combination or strategy I have is based upon the Indian Child Welfare Act, ICWA. So sometimes in cases there are major ICWA or due process violations that have occurred during the case. So you want to make sure that you look at those issues. I understand that everyone doesn't have Indian heritage, American Indian heritage, but it's something that you should thoroughly investigate throughout the case. And you'd be surprised how many people have Indian ancestry and didn't know it. So those are the 4 main things that I try to focus on. Let me answer this question from Betty Jo. Can you get a child back if you're in a homeless shelter? The answer is yes, you can. Is the social worker and the judge going to be jumping up and down to do that? No. So you're going to have the help of the homeless shelter, to show the judge that the placement of the child from foster care into your care is a good idea. A lot of this will depend on the stage of the case. Are you at the beginning? Are you in the middle? Or are you at the end? The older the case, in my opinion, the less likely that may happen. But that should not prevent you from trying. File a 388 to get the child placed with you, even if you are in a homeless shelter. A lot of times the person's in a drug rehab, inpatient drug rehab. And I have seen judges many times place children with parents in a drug rehab. During the case and leading up to the case 2-6 hearing, there are some big mistakes a lot of parents make for whatever reason. The biggest mistake I see is missing visits throughout the case. In my opinion, it might be the easiest thing to do, absent transportation problems, to build a strong case, and that's to visit with your child or children regularly and consistently. Second biggest mistake, parents wait to the last minute to implement a strategy to defeat a 2-6 hearing. Start early. You should start strategizing when the child is first taken away from you, all the way at the beginning of the case, when nobody's thinking about termination of your parental rights. The next thing that I see a lot is that parents think emotional testimony wins cases. It does not, or it rarely does. I have seen a couple of people who had emotional arguments win cases, but generally it doesn't. Generally, the judge focuses on the law and what he or she believes are the facts in the case. One of the things that you can do is you can document your visits, okay? Date, time, length, and what happened during the visit. You know, at some point in time, if you don't get the child back, somebody's going to say something, well, the visits weren't good. No, yes, they were. Here's my diary of the visits. The next big thing is people come to court without independent witnesses. Someone that's not related to you or involved in the case. So maybe you have that friend or relative or um, truly independent witness who has nothing to do with you or your family come to court and testify. Next biggest mistake I see is people do not take advantage of writs and appeals and those deadlines associated with it. Talk to your lawyer. Next thing I see, and I kind of see this often, and I'm kind of surprised about it. Parents sometimes post material that is detrimental to them on social media. And then the social worker finds it, shows the judge, you know, give you an example. I see this one kind of frequently. Parent posts something on social media about parent partying, maybe smoking weed or drinking, which are both legal in California, but it's a drug case. The kid was taken away because of substance abuse. And here you are posting your partying on social media. Of course, if they find it, they're going to use it against you. The last and the biggest mistake, one of the biggest mistakes I see, is people believing that the judge won't terminate your parental rights if the judge knows that the child loves you. In a lot of cases, I hear judges say, I realize the child and the parent love each other, but that's not what the law tells me to look at. So do not believe that that's going to happen. That emotional plea for love is going to stop the termination of your case. Cases run heavily on documented evidence, not intentions. So start your notebook, keep your documented issues or your documented evidence in one place where you can share with your lawyer in preparing for your 2-6 hearing. Okay, Miss G, that's all I have. I think we've lost Miss G kind of early in the morning here. All right, let me see if I see any questions. Here's a question from YouTube. Can someone become a foster parent with old CPS case? Just curious. The answer is yes. But becoming a foster parent doesn't guarantee that you're going to get the child placed with you. It would help. Can we get a minute for Bob? Sammy, that's a great idea. All right, let's start now and prayer. Give a little prayer out to yourself and to God and regarding Bob Pace. All right, Sammy, thank you for that suggestion. Betty Jo has another question. Why would they put a family member up on the standard in a question them? Betty Jo, I'm not sure I understand that. Do you understand that question, Miss G? Miss G, you're muted.
I don't know, Vincent. You can read it. You're the attorney.
I don't understand that question, Betty Jo. You want to rephrase it? Right, I don't see any other questions coming through. Sammy, apparently he was at home and he was having some health issues, and he was taken by, I believe, ambulance to the doctor, and it started like a snowball. Things got worse and worse, and other things got worse and worse. At one time, I thought he'd pull out and make it, but then he took a drastic left turn and passed away. We're all going to miss him. Betty Jo, why would they put a family member up on the stand and question them? Oh, for many reasons. They're going to put a family member up on the stand to help their case, to show that a client or a family member shouldn't have the child, or in reverse, they'll put the family member up on the stand to help the parent. So there's a lot of reasons why they would put you up on the stand. Betty, are you being called as a witness in the case? All righty. I don't see any other questions, and we're coming to the end of our morning office hours here on Saturday morning. Anything else you'd like to say, Miss G?
No.
All right. Well, folks, we'll see you on Monday with office hours. Have a good weekend.
A vivid picture is encrypted in your mind as the critics get in line like they're witnessing a crime. But then you notice there's a shiver in your spine from the feelings of discontentment and bitterness combined. Heartbroken when you listen to the judges. Another kid's innocence corrupted. And if you go against then it's destructive. Consider this predicament the toughest, but we believe in a system fit for justice. Child Protective Services only pretends to save it. The one solution for this is worthy of instant praises. 30 years of experience with relentless cases. Allow me to introduce them. This is Vincent Davis, defending you when they don't think a mother fits the role. Is it juvenile dependency or government control? Observe the pain in their eyes. It's time for us to realize we are the last one.